All right. Good morning, ladies and gentlemen, and apologize for the delay while counsel and I conferred in chambers. An issue has been brought to our attention, a concern that's been raised by a juror, and so we're going to need to conduct an inquiry into that matter. I'll explain that process in a moment. That I've collaborated with counsel on, that we have a process in mind that we're going to use to understand this issue more fully. I know there's one other matter that, Mr. Arbor, you wanted to put on the record regarding a communication that came several days ago. If you want to go ahead and make a record of that, sir.
Yes, sure. Thank you. For the record, and so there's no issue that we as the counsel for Mr. Broyhill have abandoned in any way our responsibilities as officers of the court to report any concerns, not wrongdoing, but concerns. Information had been given to us that there had, some parties had witnessed some of the jurors at a lunch table here in the courthouse, that they were discussing aspects of the case together. That would be a violation of their instructions as jurors to not talk about the case. It did not arise to a level where the content seemed to be of a substantive nature that required us putting something on the record at the time that would request anything beyond just alerting you to it, which we did with Mr. Fawcett present, and then your method of handling it, which we had no objection to, which was to put to recharge the jury with respect to their obligations as jurors not to talk about the case with each other. I would also add that, you know, we had put on something about the fact that they've had, because of the publicity of the case, has gotten a lot of the cautionary instructions have been directed toward avoiding press and things of that nature. So at our request, you did, with emphasis, make an instruction to the jury about not so much the press, but with each other as well, not to talk with each other as well about the case. And I, quite honestly, I can't remember what day you did it, but I do know you did it. And we had no objection to any manner in which you handled it, and we had no information that would give rise to our doing anything more than what we had done. But we did want there to be a record of the fact that we've complied with our obligations to notify the court and the state of anything of that nature, as I think both of our obligations are required to do that. I'm putting it on the record today because there's a new exhibit that has come to the court's attention. There has been we'll acknowledge some in-camera discussions about this note that you're about to talk about, and there is a procedure that we have discussed. On behalf of our client, we have suggested to the court that there be an inquiry made regarding this note, and I think you've developed a strategy by which you will make that inquiry, and we'll reserve any motions or concerns we may have until after the process is completed, and then we'll address it at that time if it needs to be addressed.
Yes, sir. All right, very well. Mr. Fawcett, anything you need to put on the record before we move to the issue at hand?
No, Your Honor, thank you.
All right, so last evening, at the evening recess, a juror mentioned to the bailiff that she had concerns that another juror was talking about the fact that his wife was watching live streaming of this case, and that she believed that he and she had had conversations about the case. The bailiff asked her to put her concern in writing, which she has done this morning. And I'll read for the record the communication we received from the juror. It says, a juror has repeatedly or excuse me, a juror has mentioned repeatedly discussing the case with his wife. Her office is live streaming the case, and he said he figured that she'd seen it, since she'd seen it on TV because it was televised, he could discuss it. He was quickly informed that was not the case, so perhaps just a reminder not to watch media playbacks or discussions with other parties would be helpful. Thanks. The process that we need to make an inquiry into this matter. The process that we have discussed in chambers and that I'll recite for the record now is we're going to ask in a moment the bailiff to take out 4 jurors from the jury room, including the reporting juror, namely the one who provided this communication to us. And we're doing that so as not to draw undue attention to that juror, at least within the jury itself. After those 4 are separated, we'll ask the bailiff to bring this reporting juror into the courtroom, at which time I will conduct an inquiry into the substance of this note and find out what she's heard, what she believes, things of that sort. At the end of that inquiry, I'll have an opportunity to discuss the matter briefly with counsel. It's anticipated that the next step would to be bring the subject juror, namely the one who is the subject of this note, into the courtroom to conduct an inquiry of that person as well, to find out what his view of these matters is, what his understanding of the events are. Again, I'll have an opportunity at that time to discuss this matter with counsel. It may be that we need to conduct further inquiry, and we'll make that decision after we go through those first 2 steps. I will note that I'm ordering that there be no video or audio feed of my inquiry with any juror. So I would ask that the media respect that order as well. Once the juror is no longer in the room, then this is an open courtroom, but consistent with Rule 15 of the General Rules of Practice, I'm asking that any inquiry of the jury not be subject to coverage. All right. So with that being said, is that the process that each of you understood we followed, Mr. Fawcett?
Yes, Your Honor.
Mr. Arm?
Yes, put a court exhibit number on the.
I'll make this court exhibit number 9. Number 9 is court exhibit number 9 is communication from the juror. All right, so bailiff, you have your instructions. If you'd go ahead and report back when you have those 4 jurors separated.